Good afternoon to you. We are continuing with the Constitution. Today we are taking up a new chapter after having completed center-state relations. Now we are coming to state executive. That is, first we will take governor. State executive. See, the Constitution envisages same parliamentary system of government at the state level. The same parliamentary system at the union and state, both same level. So in state also, the same system of parliamentary form of government applies to state also. Articles 153 to 167. 153 to 167 in part 6 applied to state executives. State executive includes governor, a chief minister, council of ministers, advocate general of the state. Just to recall, what is the constitution of union executive? Union executive consists of president, vice president, council of ministers and attorney general. What is the composition of state executive? Governor, chief minister, council of ministers, advocate general. Remember, see the difference. Thus, there is no provision for vice governor in the state like that of vice president at the center. The point you should note is there is no vice governor. Only at the center there is a provision for vice president who is the ex officio chairman of Rajya Sabha. In the state there is no provision for vice governor. Now the governor is the chief executive head of state, but he is a titular head and representative of central government. He is head of state and like president, he is also a titular head. Certain amount of discretion is there for governor, that we will come in the later. And he is the representative of central government. He has got a dual role. One, head of state of the state. Another is, people will say he is the agent of the central government. That is not we should not use such things. He is the representative of the central government. Maybe because of the system, there may be some, manipulation, etc. That we are not, as a student, we are not concerned about it. He is the representative of the state. And Article 153 says that there shall be a governor for each state, which means that there should not be any vacancy in the office of governor. It is a continuous body. Therefore, the incumbent governor continues even after the term of 5 years till a new governor is appointed. That is, the head of state cannot be kept vacant. That is the intention. 7th Constitutional Amendment Act 1956. Which Amendment Act? 7th Constitutional Amendment Act 1956 amended Article 153. Which article amended? 153. And provided that one person can be appointed as governor for 2 or more states. So, same person can be appointed for 2 or more states. This need arose because of reorganization of states. So, there may be some occasion one person has to hold 2 or more states. So, the article 153 was amended by 7th Amendment Act 1956, providing that one person can be appointed as governor for 2 or more states. The need arose because of the reorganization. That point remember. Then, governor is appointed by president. The term of governor is 5 years. But he shall hold the office during the pleasure of the president. See, not contradiction, it is a balance of power. He is appointed by President of India. His term is 5 years, but he holds the office during the pleasure of the president, which implies even though his term is 5 years, he can be removed by president at any time. That provision is always there. The qualifications for being the governor is very simple. Citizenship, number one. He should have completed 35 years of age, shall not be a member of either House of Parliament or either House of State Legislature. If such a member is appointed as governor, he is doomed to have vacated that office on the date of entry into the office of governor. He shall not hold any office of profit. He is entitled to the privileges and immunities, salary, emoluments, etc. as determined by the Parliament by law. Till Parliament determines these privileges by law, such emoluments and allowances as given in second schedule will apply. See, most important point here is the term of the governor, 5 years. But at the same time, he continues to hold during the pleasure of the president. That is why the governors are always, he cannot be, even if a government servant, you have to give notice. But governor can be removed at a moment's notice. There is no need for reason, there is no need for notice, there is no need, nothing. Secondly, supposing the same person is appointed as governor for 2 or more states. This question came in one of the preliminaries. If the same person is appointed as governor of 2 or more states, which state will bear the expenses? The emoluments and allowances payable to the governor shall be allocated among the states in such proportion as determined by, choices are 1. Parliament of India, 2. State legislature of both the states, 3. President, 4. By law. These are the 4 choices. The president is the correct answer, remember. So, when the same person is appointed as governor of 2 or more states, the emoluments and allowances payable to the governor shall be allocated among the states in such proportion as may be determined by president. So, remember, by president. Secondly, he is administered oath of office by Chief Justice of the High Court. Remember, High Court. And in his absence, the senior most judge of the High Court. The format of his oath of office has been given in Article 159, not in schedule. Remember, the oath of office of the governor is given in the Article 159, not in the schedule, as in the case of President of India. Now, like President, governor enjoys immunity from legal proceedings, and also during the term of his office, he is not answerable in any court of law for any act done or purport to be done. No criminal proceedings can be initiated against him during the term of his office, and no process of arrest can be initiated against him during the term of his office for any act done or purport to be done. No civil proceedings can be initiated against him unless he is given 2 months' notice. So, all these 6 under Article 361 apply to President also and Governor also. Both of them enjoy the immunity. Now, a governor can resign at any time by writing to the President of India. To whom you should write? President of India. Because of these are all small issues which will give to you some doubt. Some people will think that you should give it to because oath of office is administered by the Chief Justice. So naturally he should submit his resignation to the Chief Justice. No, he will submit his resignation to the President of India. Then, Supreme Court has held that the pleasure of President is not justiciable. Whether the President has appointed him or not, it cannot be questioned in any court of law. The point to be noted. The term of office of the governor has been a bone of contention for a long time by successive government, whether it is BJP, whether it is Congress. There is no party is exempted. Every party indulges in the same manipulation, maneuvering. They have been removed, dismissed, transferred at the will of the union government. The constitution does not lay down any ground for the removal of the governor. In 1989, VP Singh government asked all the governors to resign since they were appointed by the Congress government. Eventually, many governors were replaced and a few governors were allowed to continue. The same thing happened in 1991 when Narasimha Rao government took over the reins. He removed 14 governors appointed by VP Singh government and Chandrasekhar government. So, President can transfer a governor from one state to another, or governor can, whose term has been completed, he can be asked to continue for one more term, or he can be transferred to another state for one more term, additional term. Thus, a governor has been a plaything in the hands of the center. That is the truth. In one case, the Supreme Court held that the office of governor is not an employment under the union, and it does not come within the prohibition of Article 319, and therefore a member of the State Public Commission can be appointed as governor. It was also held by the Supreme Court that the governor is an independent authority and he is not under the control of the union, neither he is subordinate to the central government and he is in no way subordinate. Nevertheless, the directions of the Supreme Court is only never followed. It is followed only in breach rather than in adherence. Under the conventions, the governor should not belong to same state. He should be from other state. That is the convention. Even though Sarkaria Commission and other commissions suggested that the governor should be apolitical and should not be in active politics, in practice this is never followed. Whichever party comes to power, whatever party comes to power, this is hardly followed. In fact, Sarkaria Commission has also recommended that the Chief Minister should be consulted. But the party at the center, the government at the center, sometimes consult the Chief Minister, sometimes does not consult. So it is also left to the will of the union. Article 160 provides that the President can make such provisions as he thinks fit for the discharge of functions of the governor of the state in any contingency not provided for this part. For example, at the sudden death of the sitting governor, the President can give the charge to the Chief Justice of the High Court. Because Article 130 provides in any contingency where there is the governor, sitting governor unable to discharge his functions, the President can make such a provision. Because I presume it is not, I may be wrong also. This was in the provision because at the time 7th Amendment Act may not have been there. So after 7th Amendment Act, where it provides that the same person can be appointed for one or more states, this Article 160 may be infructuous. Because what it provides is that the President can make such a provision as he thinks fit for discharge of the functions of the governor of the state in any contingency not provided for in this part. For example, at the sudden death of the sitting governor, the president can give the charge to the Chief Justice of the High Court. This is the provision. But 7th Amendment Act already given that one same person can hold more than one state. So in that case, the other neighboring state governor can be asked to hold the charge of the this state temporarily. That is possible. However, the fact remains that Article 160 provides that the president can make such provisions as he thinks fit for the discharge of the functions of the state, the functions of the governor of the state in any contingency which has not been provided in this part. That is a fact that is under Article 160. Remember, the powers of the governor, like President of India, the governor of state enjoys executive powers, legislative powers, ordinance making powers, financial powers, and judicial powers. But remember, most importantly, he has no diplomatic powers, he has no military powers, he has no emergency powers. So with this we will end the class. We will continue with the class tomorrow. We will give the actual powers of the governor in the next class. Thank you.